Looks like the attorneys are ready. Our next case for oral argument is in re the marriage of Mary Frazier, now known as Mary Stryker, and concerning Shannon Frazier. Mr. Davidson, you may begin.
Good morning, and may it please the court and learned counsel. Your Honor, this is a case on further review from the Court of Appeals, but it presents a fairly broad issue that has not been addressed by the courts in Iowa previously. To my knowledge, there is no other case decided by either this court or the Court of Appeals addressing the particular issue that we have here, which is when parents are divorced and are awarded joint legal custody, does the court, in the absence of a petition for modification or frankly any other petition, have the right to make a decision when the parents reach an impasse? It is our position, Your Honor, that there are two issues in this case that cause the district court to dismiss the petition or dismiss the application because there was no petition, and secondly, should cause this court to uphold the decision of the district court. Firstly, Your Honor, the issue of is there a pending action is one that this court will need to decide. The Court of Appeals utterly failed to apply the rule 1.301, which states that a cause of action is commenced by filing a petition. The rules and the code also require that upon the filing of the petition that a filing fee be paid, that an original notice be issued, and that the defendant or the respondent be served with process. None of that happened. Mary admits that she did not file a petition, that her application is not a petition. She did not pay a filing fee. She did not obtain an original notice, and she did not serve Shannon with any service of process. So, Your Honor, what I would suggest here to the court is that what we have is a big fat nothing burger. There is no petition, and
I think that you're right, that an application for vaccination determination isn't something that we have typically recognized. But we do say that as a general matter, we put substance over form when parties make filings. And so if parties label something the wrong thing or give it the wrong name, we will consider it to be kind of what the substance of it actually is. Does that apply here? Does that sort of fix this application for vaccination determination?
I don't think so. Our rules are not technical, and they're simple. You file a petition and you pay a filing fee. We don't have code pleading. We don't have magic words. So even if the application was a petition, she didn't pay a filing fee. She didn't serve an original notice.
Matter of modification also requires substantial change in circumstances not within the contemplation of the court at the time. Were those things alleged in the application?
Absolutely not. And
pretend like we're going to call it a petition. It's going to be a petition for vaccination. Not even the guts of the petition were included in addition to a procedure. Am I correct?
You're correct, Your Honor, and that raises the point I'm trying to make here, is that Mary strategically did not call this a petition, because if it was a petition, there's only one type of petition she could have filed, and that's a petition for modification. And in a petition for modification, the court is required to find a substantial change of circumstances since the entry of the original decree. Mary strategically did not call this a petition because she did not want to be saddled with the requirement that she show a substantial change of circumstances.
So does Mary could she have done anything to get the issue that she wants to decided by a court?
She could have petitioned for modification and asked the court to grant her sole legal custody on the issue of medical decisions.
Was that her only option?
Appears to me to be her only option, Your Honor.
On a you said to grant her sole legal custody with respect to medical decisions. I thought our case law indicates that you can't divide out legal custody that way.
I don't believe there is a Supreme Court case on that point, Justice. The Court of Appeals certainly has held in the last 15 years that joint legal custody cannot be unbundled, cannot be a la carte, and that the court cannot grant sole legal custody for medical decisions.
Let's say that you're correct and that she should have filed a petition to modify legal custody with respect to medical decisions. As a practical matter, are you saying that the district court has some authority to adjudicate this dispute and the issue here is it just was in the wrong package?
I think, Your Honor, that first of all, the packaging is important. If she files a petition for modification, she has to allege and prove a substantial change of circumstances. She has to allege enough that perhaps she's entitled to sole legal custody of the children, and then she can make those decisions. But what we have here is a petitioner who knows she can't prove that, and so she tries to get through the back door, what she's never going.
I mean, if you're saying that you can do a la carte legal custody arrangements, and she comes to the court and says, my spouse and I, or former spouse and I, have 50-50 decision-making capacity, the change in circumstances is the decision can't be exercised because we disagree. It seems to me that that's more than sufficient to establish a change in circumstances.
I agree with the idea that you can have a la carte joint legal custody.
You said you could.
I did not say you could, Your Honor. I said this court has never ruled on that issue.
Can the court make a decision on this issue? And I thought your answer was yes, she could have done something different. Now you're saying no.
Saying no, the court cannot have a la carte joint legal custody decisions acting in the role of a judicial tiebreaker. She has a remedy, Your Honor. That's to seek sole legal custody. Complete sole legal custody. But she didn't do that because it was a loser.
There's some language about, there is language that says something like, neither party shall initiate any legal action regarding the above issues, and that includes medical decisions, without first attempting to resolve the issue through a counsel or mediator. That almost sounds like they reserve the right to, if mediation is unsuccessful, go to court, and they put it in the decree. Am I wrong about that?
I'm familiar with that language. I wasn't counsel for Mr. Frazier when that decree was entered. I don't know exactly what it means other than the parties agreed to participate in mediation before commencing legal action. Now, I don't know what that legal action is that they would commence. It certainly says absolutely nothing about the court reserving jurisdiction to decide those issues on an a la carte basis. And the cases are very clear that reservation of jurisdiction in divorce cases are extremely rare and extremely frowned upon.
That had occurred, and that does occur, it would be all right. What if the decree said, the parties will sell the marital home, and down the road, if there's a disagreement, the court reserves jurisdiction to resolve the dispute or something like that. Would that be all right?
First of all, I would refer the court to the recent case of Wallace versus Wildnessy, where this court held that even if the parties agree, the court cannot exercise jurisdiction in a domestic relations matter unless it's authorized by Chapter 598. In that case, the court held that when the parties attempted to enter a qualified domestic relations order with respect to a pension plan without a petition for divorce pending, the court very clearly said, we have no authority.
There was no divorce decree to begin with. I'm talking about, what if the decree had said, I'm not saying this decree said so, but what if the decree said, if disagreements arise between the parties with regard to significant medical decisions, the court reserves jurisdiction to resolve those disputes.
I think the rule is that reservation of jurisdiction in a divorce decree is extremely rare and extremely limited, and lawyers or judges putting provisions in divorce decrees that get through the back door, what you can't get through the front door of having a la carte joint custody is exactly what you're suggesting, is that if the court says there is no such thing as a la carte joint legal custody, but if we reach an impasse and we are unable to resolve that impasse, the court will step in and act as a tiebreaker. Now the court has done exactly what it said cannot be done, which is create a la carte joint legal custody.
Practical question. If you have a set of parents who agree about 99.99% of all the issues affecting their children, and they disagree about this one issue, what is the practical point of forcing them to litigate legal custody in total when they really only have one minor disagreement? And now we're going to give one parent absolute decision-making authority over the other when it's wholly unnecessary to achieve the equitable outcome.
The answer I would give you, Your Honor, is this. The legislature created the policy. All divorce law is statutory. It's like the tax code. The legislature indicated in Chapter 598.
So the Constitution says district courts shall be courts of equity, correct? And we have a long line of cases that say once a district court has exercised jurisdiction over a child in a dissolution proceeding, the court always has equitable jurisdiction over the child whenever the parent brings the child before the court, however it's done. I think that's the law in Iowa. As I've looked at all the persuasive authority, that seems to be the law in every jurisdiction in the United States. So when we're dealing with equitable matters involving the child, why doesn't the Constitution give the district court sufficient authority to exercise jurisdiction here?
I would suggest that the legislature has created the policy, and if the court is looking to the statute to create a new cause of action, the court has to find it somewhere in the legislative statute.
Legislature created the policy, which they do. It's our job to interpret the statute. So I think the Court of Appeals was really concerned about the idea that under 590.8.13, it specifically says that neither parent has legal custodial rights superior to those of the other parent. And so as we interpret that, what are we supposed to do with that when you have a situation where the holdout parent really is exercising superior authority?
Suggest you do exactly the same thing that the court does for married parents and for parents that have never been married, and that's do absolutely nothing. I know it's hard for lawyers to accept the idea that the court does not have a remedy.
The legislature, like you said, sets policy, and they specifically said neither parent has superior rights. So we don't have that same provision for unmarried parents or continuing, parents that are still married. It's within the divorce statute.
I would suggest that when a child has two parents, those parents have the legal rights that they have at law to make those same decisions.
Divorce setting, that sometimes, in my professional opinion, is why some people stayed together, because they didn't want to deal with having perhaps a little bit more scrutiny once they're in the system. Like it or not, our statute does allow the state to be a bit more involved in the lives of children with parents who are divorcing or parents who have gone through a legal proceeding. I want to twist the facts a little bit to make it be something maybe that's a little bit more palatable to people understanding. COVID's a hot button. COVID shots are a hot button. Let's say it's cancer. Cancer and a treatment that has all kinds of research and support to say this treatment will save this child's life. Without it, she will die. Black and white, and it'd be really hard to find perhaps maybe a professional that would say otherwise. Put that in this set of facts, and let's say dad's saying, no, I don't want it. Are we saying she has to go through a modification proceeding, which we all know, we've all been lawyers, how long start to finish a proceeding can take? Whereas this application may have been a bit of a shortcut,
Your Honor, I see my time is up.
because I asked it.
My view on that, Your Honor, is if a child's life is in danger, that is a China petition. That there are,
And assume the court says, no, it's not. Assume you get turned down on that. That is not a China petition. You've got one parent willing and able to do what they think is the right thing. China's not going to get involved. They're going to say, you got a good parent, go figure it out.
I guess, Your Honor, the answer that I would give to that is, what if one parent says, I want to raise the child Jewish, and the other parent
Pattern.
says, I want to raise the child Christian?
Sir, life and death. What?
Parents have to work it out. There isn't anything in the statute that says that because it's an important question, or because it's a question that the court thinks is important, or that society thinks is important, that the parents shouldn't go just have coffee and work it out, just like parents who are married, just like parents who are never married. The same fact, the same.
So are you familiar with our Helton case?
I don't believe so, Your Honor.
Say, when it comes to dissolution cases involving children, statutory regulations as to the custody and care of infants will not affect the court's jurisdiction. It exists and has been exercised by courts of equity for more than 2 centuries in England and in different states of this republic for shorter periods of time, but for like purposes and reasons. And then it goes on for, and I won't read it all to you, probably 4 pages, of why courts always have inherent authority to adjudicate the rights of parents with respect to children. And it's very similar to what the Chief Justice is asking, which is at some point, the state has an interest in resolving disputes over children, period, full stop.
Well, Your Honor, I am.
Rule that case to rule in your favor.
So, because the Helton case is from 1950, and it was not decided under the current form of Chapter 598, and it was involving a court decision regarding awarding custody of the children in the best interests of the child. And the court no longer has to look to inherent authority to make those decisions, because the legislature has now adopted a statute which specifically says custody determinations are to be made by the court using the best interest of the child. That's the only issue in that case. That case did not involve the circumstances that we have here. So, Your Honor, I would respectfully suggest that the decision in that case has been not overruled, but superseded by the statutory procedure that the legislature adopted when it adopted the current form of Chapter 598, which is subsequent to the Helton case. Thank you.
Thank you. May it please the court, Mr. Davidson. I'm Jacob Koller. I represent Mary Stryker in this appeal. I'd like to start where the Chief Justice ended, and it's with that fact pattern and with a response to that specific question. If mom and dad divorce and they have joint legal custody of their healthy toddler, and for 10 years they get along perfectly well and co-parent successfully, but a decade later, that child develops a rare or serious medical condition for which the only cure is a life-saving surgery. And mom wants to proceed with the surgery without delay, but dad, for religious purposes, objects to the surgery. The question is, what are the mom's options to present that issue or to decide that issue? And the answer to the question is, under Mr. Frazier's argument in this case, the surgery doesn't happen. The child doesn't get,
That was a hard one for him, but thinking like a lawyer, file a modification, substantial change in circumstances, kid's going to die. This was not within the contemplation of the court. And you also are going to have to prove superior parenting. There's 3 things you have to prove. Why not? Why not jump through the hoops? There's a way to do it. You could probably even get expedited if it was a life and death decision. Why not?
there's lots of reasons, and I appreciate counsel at least giving Mary's case credit by suggesting that the reason for filing the application was strategic. But to be very clear, this was not filed as a modification because there wasn't and isn't an argument that there was a substantial change in circumstances not contemplated at the time of the decree. The pandemic resulted in the need to make medical decisions that were perhaps different than what medical decisions needed to be made in 2014. But it's not a change in
Contemplation of the court, doesn't it?
I don't believe so, Your Honor. The court in the decree ordered joint legal custody in 2014. It contemplated specifically within that decree that legal decisions would have to be made. So that defaults to the statute that says when legal decisions have to be made, neither parent's rights are superior to the other. So the fact that
Pediatrician recommend.
we didn't get to the merits of the case in Clinton County, but the pediatrician submitted an affidavit recommending that the children be vaccinated against COVID-19.
I mean, I don't know. I've been through a divorce, and my ex-spouse had primary physical care. And if my ex-spouse thought something was a good medical decision, and it was the one that the regular pediatrician recommended, that's kind of how it happened. It doesn't, you know, a tie doesn't, in views of the parents, doesn't necessarily mean nothing happens, does it?
Does in a situation in which, if you don't agree, your consequence of that is the possibility or the prospect of a contempt action filed by the parent that objects on the basis that you've unilaterally taken action in contradiction to his rights as an equal decision maker.
About the provision that says either party may request a second independent professional opinion. Did the dad get a second opinion?
No action. And, you know, in the initial hypothetical that I provided, big picture, I specifically made the example being a religious objection, which we could all agree is appropriate under certain circumstances. In this case, I don't know that there was an appropriate objection. I would call Mr. Frazier the obstructionist parent in this case. And he didn't submit any medical literature or any other information to justify his position. He simply took and continues to take the position that if I object, regardless of the reason as to why I object, this cannot happen because we have equal rights. And nobody, including the court, can step in and say otherwise.
And you can't try to answer another question. You have to answer this question. Why did she file an application instead of going through what is considered normal procedure, a modification?
So,
Not persuaded, and you can tell me otherwise, that the court has reserved jurisdiction in this case. Let's assume there's no reserved jurisdiction. Why'd she do it this way?
so number one, it's not a modification because Mary isn't pleading a substantial change in circumstances not contemplated at the time of the decree. The reason for that, Your Honor, is that in the decree, there clearly was an expectation that as joint legal custodians, they would have to make medical decisions. There wasn't speculation or prediction as to what each of those medical decisions would be over the course of the next 12 years, but that those decisions would have to be made. That incorporated the statutory framework that says we're equal.
But you know, you said that your client, I mean, let me play this out some more, where you say your client runs the risk of contempt by getting the children vaccinated if at the pediatrician's recommendation. I mean, it says the decision should be a mutual decision, but getting them vaccinated is a decision. Getting them not vaccinated is a decision. I mean, either way, it's not a mutual decision.
The court at some point has to be an arbiter, because absent the parties agreeing, the parents agreeing, the winner in that dispute is the objector, which is why it's not equal.
Necessarily. I think doing nothing is also a decision.
It discusses the desire to avoid situations in which you put a parent in the situation that they have to ask forgiveness as opposed to seek permission. I would argue in this case that Mary did everything the right way.
Seeking permission, you have said that modification is not the proper way. What is the authority that allows you to do what you did?
Outside of the modification, well, I think number one, 598.13 that provides for joint legal custody, 598.41 that addresses joint legal custody and the best interest of children, 598.
Setting aside, had you filed a petition rather than an application, and setting aside some of those jurisdictional issues, once joint established by the decree, what allows you, short of modification, from coming and asking, what authority gives the court then the power to make that tie-breaking decision?
I'd start with, Your Honor, inherent authority. More specifically, there are rules and statutes that need to be applied and interpreted. But the Helton case, as one reference in terms of the court having inherent power and jurisdiction involving custody of minor children, there's this court's reasoning in the Hogue case in 2001 that describes inherent authority as fundamental to the powers delegated by the Constitution or by statute, that courts possess broad powers to do what is reasonably necessary to discharge their traditional responsibilities. In 2001, again in this court, in Ray K.N., the court cited a Sun Prairie case issued by the Wisconsin Supreme Court that discusses the importance and the necessity of the court's inherent power.
Question. So a decree is a little bit different than a judgment, let's say, in an action at law. An action at law determines the rights of the parties at the time of trial. It's done. A decree is an injunction, a divorce decree at least. It regulates the parties' conduct going forward. Why wouldn't the court always have inherent authority once a party seeks relief under the court's order to go back and interpret or enforce the injunction? I mean, that is what a decree is, right? It directs parties to do particular things. The court always has the authority to go back and revisit an injunction, which is all a divorce decree is. Can't we think of it that way?
Yes, is the short answer. I don't know that I would term it as an injunction because I think that has some technical substantive meaning. Well, absolutely, and there's a litany of cases that deal with or are within the context of the court having the tiebreaker authority. So the argument.
So are there any of those cases that do it in this context where it's just sort of a one kind of rifle shot application to do X that isn't in the context of a decree itself or modification or injunction? I didn't see any. I didn't see any that were like this, asking for sort of a single decision on kind of one point.
Cases, Your Honor, aren't clear as to whether or how it was brought to the court's attention. Many of the cases refer to, within the process, applications for determination having been filed. Some are within the modification context, but there's still standalone motions within the modification context, not decided as part of the modification. Some were filed as requests for injunctive relief, where the court said, this is a request for injunctive relief under the guise of a modification.
Here, right? I think that's what Harder did.
What I did here, or what Mary did here, was pursue it based upon what she believed and believes to be the appropriate course of action. I mean, there are both legal and practical considerations that go into that. But again, it's not a modification. A modification, as counsel indicated, would be the effect of going back to court to ask the court to strip Mr. Frazier of all his legal custodial rights. It's the next thing to a termination of parental rights.
So every time parents disagree, they're going to be able to go to court and just ask the court to be the tiebreaker?
Yes is the answer, but the floodgates argument doesn't make a lot of sense to me. Number one, I've been doing this for 20 years.
Suggesting a floodgates necessarily, but there's a statutory scheme that allows for modification, but doesn't allow for the court to be the, I mean, to your point, what basis is the court going to decide if it is a religious versus a pediatrician recommendation? I mean, how's the court going to be that decider when those are really issues for the parents?
Same way that the court decides original proceedings as it relates to physical care on a daily basis, which is they have to take the facts and circumstances presented to them. The same thing. I mean, I think we all agree that if this dispute were before the court in an original action and the court needed to determine some legal custody issue, it certainly has the ability to do so within that context. I have a lot of faith in our judges being able to make decisions based on the best interest of the children, which, even the rules of appellate procedure recognize as a proposition so well-founded that it doesn't even require citation.
Go ahead.
Well, let's play this out because in your experience in the family law area, I'm sure you see a lot of conflicts over small issues, right? I mean, when I was on the district bench, we'd have motion to decide which school the child should go to. This would be filed like a week before school starts, right? And then soccer versus taekwondo, and on and on. To think about all the possible disagreements where there's no clear answer, it's just going to come to the judge. There is a floodgates issue here, isn't there?
I agree with that, Your Honor, but I understand the point and the suggestion, and that is, in the 20 years I've been practicing, I've always understood this to be an available mechanism, and it's something that I've utilized multiple times. It's something that I've been on both sides of these sorts of applications. So to me, this is not an opening of the floodgate. This is this court's opportunity to set the law of the land so that we no longer have to go to, continuing legal seminars to determine what we can or can't do. So I don't think there's a floodgates issue here. We are gatekeepers. There is always a cost-benefit analysis with regard to whether or not it's worthwhile to bring something before the court because we have a dispute on whether our kid should play soccer versus something that requires.
Time is up. What if this whole argument had been made at the time of divorce? I'm imagining myself on the trial court bench, got husband and wife, they've agreed on custody, they've agreed they want to do shared care, but they've got this big, fat, ugly issue about the COVID vaccination. And let's say they litigate the heck out of it in front of me at trial. Everybody's filed the petition for divorce, an answer's been filed, the service of all that stuff happened the way it's supposed to, and it's before me, and maybe you each have an expert. Couldn't a judge be persuaded, you two can't figure out how to work this out together, and this is an important decision, and instead of me deciding what it's going to be, the court could say who's going to have legal custody. The reason I frame it that way is that they could give sole legal custody. That sounds to me like perhaps maybe grounds for a modification and argue the whole thing. Once again, I'm circling back to, wouldn't that be the more acceptable route and as provided for in 598, put the other side completely on notice and give the court a chance to look at the parenting so we don't have to decide each issue individually, but globally, how are these parents getting along?
I think so. 598 strongly prefers joint legal custody. To order otherwise requires a citation to clear and convincing reasons. We want, as a public policy of this state, both parents to be involved in major decisions involving the kids, and to strip a parent of that because they can't agree on a particular or isolated issue, that's exactly the situation in which we need the court to come in as the objective arbiter and make a decision based on the information presented, what is in the children's best interest. I would note, by the way, in Rule 1.431, that's where it provides for motions to be filed, and there's been a lot of reference in this case to Rule 1.301 as a new action. A new action wasn't filed here because an action already existed, and the court had jurisdiction, continued to have jurisdiction, and that meant and means that the court can continue to make decisions based on the best interest of children. Thank you.
Thank you. There's a few points that I would like to cover in rebuttal. Firstly, that the issue of the floodgates and that not being present, it is certainly present here in this case. If this court says that the court can act as a judicial tiebreaker on the 4 reserved rights of joint legal custody, it seems to me that the court is then going to be entertaining petitions for a child, whether they should go out for soccer or football. And mom thinks because the child is good, the child can get a college scholarship and should play football. Dad says it's too dangerous. I don't want my child to be hurt. I think he should play soccer or cross country. How in the world is the court going to make that decision? The easy ones are a medical decision that's a life-saving treatment. The hard ones are the ones that this court should be concerned about. How in the world is the court going to make a decision on any of those hard questions that's going to be any better than flipping a coin? And I would submit to the court that the court is not equipped to make those decisions, which is exactly why the legislature has reserved those rights to the parents. And
Kind of speaks to what the point I was trying to make before. Doesn't it make more sense for a court to be the arbiter of who's going to make the decisions and not so much what the answers would be?
perhaps in the issue of legal custody of the children. Is it sole legal custody? Certainly, if the court is going to award sole legal custody, the court has to have clear and convincing evidence, because joint legal custody is preferred. That policy is one that is made by the legislature.
Say this was raised during the trial of the divorce, and the court had the chance to weigh those options. And so there could be clear and convincing evidence to a court at that point that if a serious medical decision, you guys are going to fight about it, I'm going to give it to one parent.
Would be a basis for awarding sole legal custody to one of the parents because the parents are not able to cooperate.
For a modification.
She could come to court and ask for sole legal custody because the parents are at loggerheads over various things. It also has a filtering effect, I might suggest to the court, in that not being able to run into court over every little dispute causes the parents to choose those issues upon which they want to fight and those which they want to compromise. Is this the hill on which one parent or the other chooses to fight that battle? Exactly the same as parents who were never married, parents who are still married. They have no right to go to court and ask the judge to decide whether the children should be Jewish or Christian, or whether the parents should get vaccinated, or the children should get vaccinated or not vaccinated. Where in 598 does it say that divorced parents check their legal rights at the courthouse door? It doesn't. I think the legislature has preserved those legal rights, and the court should recognize that.
Statute. What is there a statutory provision that disallows this?
Your Honor?
Provision that disallows this?
There is no statutory provision that says the court has or does not have the authority to entertain a disagreement between the parties concerning
That you're relying on.
98.1 subsection 3, which defines joint legal custody, Your Honor.
Turn harder.
Not have to overturn Harder, because Harder decided a question of whether the court had authority to modify child custody based upon a Missouri decree. And I would suggest to the court that, first of all, Harder has been overruled by statute. The Uniform Child Custody Jurisdiction Act now says that the home state of the child is the court that has jurisdiction to decide custody, and that the court no longer has to look to inherent authority to determine that whether or not to grant the sister state decree jurisdiction and reserve jurisdiction to the sister state. That has now been decided by statute. Harder stands only for that proposition, Your Honor. That issue is not before this court. The issue before this court is how do we interpret Iowa Code Chapter 598 in its present form.
Is, of course, that it's a case, doesn't even involve two parents duking it out on legal custody. It seems like a stretch. Is it just dicta, what perhaps was stated?
The Harder case, the father was not even a party. There were two parties in that case, the mental health provider and the mother. The mother took the children to the mental health provider to seek counseling for issues that had arisen because of the parents' divorce. The mother then sought the medical records of the children, and the mental health provider refused to provide those on the basis of privilege, not on the basis of she's divorced and not entitled to the medical records. And for whatever reason, the court then quotes from a divorce case in New Jersey talking about when the parents disagree, the court has to step in. Well, the parents weren't disagreeing in that case. It was the mother and the mental health provider. The mental health provider believed that the older children had a right to have their medical or their mental health issues to remain privileged, and ultimately the court agreed with that and did not authorize the mother to obtain copies of the mental health records from the mental health provider.
Can I ask one question, Chief? Just one question for you. Just walk me through, I want to fully understand your statutory argument here. So walk me through this just really quickly. So what provision are you reading that implies that the only way the court can exercise authority over this child is by filing the petition? What statutory provision?
It's a combination of two, Your Honor. First, 598.1 subsection 3, which defines joint legal custody as the award of legal custody of a minor children to both parents, under which both parents have legal custodial rights and the responsibility toward the child, and under which neither parent has legal custodial rights superior to those of the other parent. Then it goes on to give a list of 4 items that are specifically reserved, but including but not limited to legal status, medical care, education, extracurricular activities, and religious instruction. The combination that I'm referring to, Your Honor, is in Rule 1.401 is there is no action unless there's a petition. Somebody has to file a petition, and the petition has to be under Chapter 598, authorizing the court to take some action. And as in the Wallace case that was decided in May, if 598 doesn't authorize a particular action, now it could be implied. I would admit that there are implied causes of action within statutes that the court recognizes all the time, but the court would have to analyze that statute and determine whether or not that statute impliedly authorizes the court to make a decision on behalf of the parents who are in disagreement regarding the exercise of their joint legal custody.
Let me try and help you out, Mr. Davidson. I'm going to throw out a theory, and that is you have a divorce decree out. You can go to court to modify it. You can go to court to enforce it. You can't just go to court and say, I want a question answered because it's relevant to the divorce. We're not in the answering questions business.
That's our position, Your Honor. You can file a petition to get a divorce, you can file a petition to modify the divorce, or you can file an enforcement action. That's the only rights that the court has under Chapter 598, and expanding that without finding an elephant in a mouse hole, it's just not there.
And it's not unique to divorce, it's kind of true of equity in general. You can't just go into the court and say, I want a question answered. It has to be taught, if there's a decree, it has to be connected to the decree.
And in our view, Your Honor, the divorce was over in 2014. The case was closed. The fact that the clerk chose to put the same case number and reopen the case is of no consequence. That's an administrative matter.
Why can't this be viewed as an enforcement action? She has a legal right to make a decision. She's asking the court to enforce her legal right. Right? They have equal rights. He doesn't have rights superior to her. She doesn't have rights superior to him. She's asking for somebody to enforce her 50% right to make a decision with respect to the health care of this child. Somebody has to win and lose, but that doesn't mean it's not an enforcement action.
Our view of that would be that the court picking one or the other is now getting through the back door what the court has said and the legislature has said can't be obtained through the front door, which is a la carte joint legal custody. It's all or nothing. Thank you.
Thank you. The case of in re Marriage of Frazier is hereby submitted, and court is adjourned for the morning.